So first I will start with the anticipatory bail. So basically, I would like to first say that the for getting an anticipatory bail, the anticipatory bail provisions are mentioned as per section 438 of the CrPC. So there are the guidelines for anticipatory bail that it should not be more than 8 weeks. Then it says that every arrest must be in accordance with the procedure which is established by the law. So the anticipatory bail is being as a provision for protection of personal liberty, and it is a right of life of personal liberty to the accused. So basically, what is an anticipatory bail? It is a provision which enables a person expecting an arrest of a non-bailable offense to apply for a bail beforehand. A person can apply for anticipatory bail even before they are arrested by the police. However, the police needs to fulfill an eligibility criteria in order to apply for this type of bail. There are the numerous guidelines by the Honorable Court as to how this anticipatory bail should be applied, and the anticipatory bail can be applied before the Honorable High Court, Sessions Court, and the Supreme Court. So basically, it is basically a bail before an arrest. So any person who feels that there is an apprehension of arrest under a non-bailable offense can apply for this anticipatory bail under the provisions of Section 438 of CrPC. So anticipatory bail is granted when an accused is anticipating an arrest. So under an Indian criminal law, it allows a person to get a bail in anticipation of an arrest for committing a non-bailable offense. So a person should fit into an eligibility criteria. There are some eligibility criteria wherein the honorable courts give the anticipatory bail to an accused. As clearly stated by me that the section is already stated, the anticipatory bail is already stated in the section 438 of CrPC. So in certain cases where the accused is charged falsely, or it has been wrongly, or if the police has wrongly lodged an anticipatory, or if the police has wrongly lodged an FIR against an accused, then in that case the person can approach before the Honorable High Court or the Sessions Court or the Supreme Court, stating that an anticipatory bail must be granted. So basically, all must be having a doubt as to what can be the anticipatory bail cost. See, on a cost for getting an anticipatory bail starts from 50,000, and it depends upon case-to-case basis. If there is a serious offense, then the bail cost will be more higher. So the court can take the decision of accepting or rejecting the bail application. The cost of anticipatory bail also depends upon the skill of an individual lawyer. A skilled lawyer can help an individual to get cheaper bail than an inexperienced lawyer. So there are the numerous conditions as to when the anticipatory bail applications can be allowed by the Honorable High Court or Sessions Court or the Supreme Court. So whenever an application is made before the Honorable High Court, Sessions Court, or Supreme Court, they evaluate the application. The court may grant the bail on the following mentioned conditions. Number one, the accused will have to remain present before the police station in every month, and the accused will have to maintain a diary. Okay. The second conditions must be the accused should not tamper the witness. The third condition shall be that the accused should not threaten the witness. The fourth condition shall be that the accused should not abscond and should not flee out of India. So these are the conditions wherein if the court feels that yes, the accused will comply with all the conditions and will also remain present during the trial, then only the anticipatory bail application is allowed, and the person can be granted a bail under section 438 of CrPC. See, you can read that it's clearly stated that the accused must not leave India without taking prior permission from the Honorable High Court or Sessions Court. The anticipatory bail can be issued only by the High Court of a state or Sessions Court. It empowers the accused to seek a reprieve from arrest. So basically, who can apply for anticipatory bail? Any Indian citizen accused of a cognizable or non-cognizable offense and expecting an arrest can approach a Sessions Court or High Court to get an anticipatory bail. Generally, people apply for anticipatory bail when they believe that they have falsely been implicated in a case or have been subject to cooked up charges and might get arrested. So, an example of anticipatory bail is that if one is falsely being charged by someone in a false case, then one can apply for an anticipatory bail. The rules are already stated as per the criminal procedure code. So, but one thing is to be noted that if there is any habitual offender who is committing an offense day by day, then the court may reject this anticipatory application. So it's clearly stated that proclaimed offender not entitled to anticipatory bail under section 438 of CrPC, and this judgment is clearly stated by the Allahabad High Court. So we can now just see that anticipatory bail can be granted, but there are some conditions wherein the anticipatory bail can be cancelled. So the anticipatory bail can be cancelled by the Honorable High Court or Sessions Court or by the Supreme Court, and the court can direct the police officers to arrest a person who are on bail. So this normally can happen when a person is not obeying the rules which are being laid down by the court of law. So this can be the reasons wherein if the person is not appearing before the police station during an investigation, or if the accused is not every time attending before the police station in every month, if the if the accused is absconding, if the accused is threatening or tampering the evidence or the witness, then these are the conditions wherein the bail can be rejected by the honorable high courts, and the courts can direct the courts can direct to arrest the accused. So everyone must be having a crucial doubt as to when this anticipatory bail is granted by the courts. Then what are the validity of this anticipatory bail? To be clearly, I'll tell you that there is no such validity of anticipatory bail, because I would like to give you one case wherein in Sushila Agrawal versus State NCT of Delhi on 29 January 2020, the Honorable Supreme Court of India stated that the police cannot arrest a person who has been granted anticipatory bail by the concerned court until the completion of the trial. So whenever there is an order or a relief granted, that is the bail granted to an accused, then this bail is valid up till the completion of the trial. So there is no such validity. But if the Honorable Court has given an interim bail, then in that case, it is only for a limited period. Then after the limited period gets this over, then the person can be arrested. So if an interim bail is given, then the person can be arrested. Otherwise, there is no mentioning of interim bail. Then the validity is till the completion of the trial. So in the case of Lavish versus State, the accused was not available for interrogation and investigation and was declared as absconder. It was written that when a person against whom a warrant has been issued is absconding or concealing himself in order to avoid execution of the warrant and is declared as a proclaimed offender. So in terms of Section 82 of the Act, he is not entitled to the relief of anticipatory bail. So if the person is not complying with the orders of the Honorable High Court, Sessions Court, or the Supreme Court, wherein the Honorable Court has given some conditions which has to be followed, and if such conditions are not being followed, then there are the chances wherein the Honorable High Courts or the Sessions Court or the Supreme Court of India can cancel the anticipatory bail granted to an accused, and the person can get arrested by the police officer. So this is the topic wherein it is clearly stated about the anticipatory bail under section 438 of CrPC. Now we will discuss with the other topic. We will be covering the topics that is from section 200 of CrPC to section 203 of the CrPC, which says that when a complaint can be filed before the magistrate. See, the term complaint refers to any assertion made before a magistrate, either orally or in writing, according to the Code of Criminal Procedure. So it is done without a police report, but with the intention of initiating an action under this code against some person, known or unknown, who has committed an offense. So basically, what happens that this section is applicable only when must have heard that when a person approaches before the police station, and what if the police fails to lodge an FIR? Then in that case, the remedy before the person is that the complainant is that the complainant can approach before the magistrate court and give a complaint that this is my complaint, and accordingly an investigation must be done, and then police must be directed to lodge an FIR, and a criminal case must be lodged against that person. So these are the sections wherein under section 200 to 203 comes into the picture. So section 200 of the CrPC deals wherein there is an examination of the complainant and other witnesses in a criminal case. It lays down the procedure that a magistrate needs to follow when receiving a complaint of an offense directly from a private individual and not through the police. After the complaint is filed, the magistrate shall examine the complainant and other witnesses present. The purpose of this examination is to ascertain whether there is a sufficient ground for proceeding with the complaint. If the magistrate feels that there is no sufficient ground to proceed with the complaint, then Section 201 comes into apply. Section 201 of CRPC deals with the procedure that the magistrate needs to follow when a complaint is made directly to them and they find that there is no sufficient grounds to proceed with the complaint immediately. So in such cases, the magistrate can postpone the issuance of process, that is summons or warrant, against the accused and direct an investigation to be conducted by the police. This section is mainly concerned with the cases where the magistrate chooses not to take immediate action on the complaint and decides to investigate the matter further before summoning or arresting the accused. So basically in 201, the police, sorry, in section 201, the magistrate issues the process. The magistrate can postpone the issuance of process and can direct the police station to investigate into the case. Under section 202, the magistrate postpones the issuance of process against the accused when a complaint is made directly to him. Instead of immediately summoning or arresting the accused, the magistrate can order a preliminary inquiry or investigation by a police officer or any other person authorized by the magistrate. So the purpose of this inquiry is to determine whether there is a sufficient ground to proceed with the case and whether it is necessary to summon or arrest the accused. So basically, the magistrate tried to first direct the police authorities to investigate into the case, whether it has a sufficient cause to lodge an FIR against that person or not. So as per section 203 of the CRPC, if the judicial magistrate determines that there is not enough evidence to move forward in the case after taking into an account the statements of the complainant and its witness under section 200 and the findings of the investigation under section 202, then the magistrate shall dismiss the complaint with brief recorded reasons. So only in rare circumstances could be a second complaint based on the identical facts be taken into consideration. So section 203 of the CRPC grants the magistrate the authority to dismiss the criminal cases in their early stages if the magistrate feels that there is no sufficient ground or a cause has not been produced before the magistrate court. The power of dismissal serves as a safeguard against malicious or baseless complaints, protecting the innocent individuals from unwarranted legal consequences. So the magistrate employs the prima facie test to determine if the complaint contains enough evidence to suggest that the accused may have committed the offense without delivering it the case of the merits. By enabling this proactive role, Section 203 ensures a fair and efficient criminal justice system. This saves the time wherein the court feels that this complaint can be dismissed at an initial stage rather than taking the up the trial, dragging up the trial. So this is a very crucial step wherein the magistrate investigate the case by directing the police officers to investigate it. So after examining the evidence, if the magistrate finds sufficient grounds to, then he issues the process against the accused. Process is nothing but issuance of the notice. So the complaint copy is being sent, the notice is being sent to the accused. So this means that the process has been issued. So this is issued under section 204 of the CRPC. However, if no prima facie offense is established and there is no insufficient ground for proceeding, the magistrate dismisses the complaint under section 203 of CRPC. So the significance of section 203 of CRPC lies in its power to enable magistrate to determine the merits of a complaint and decide whether there is a sufficient grounds to proceed with the case or not. This section acts as a crucial safeguard against frivolous or baseless complaints. It protects the innocent individuals from unwarranted legal consequences. Section 203 ensures the fair and just proceedings, preventing arbitrary dismissals, and ensures that only genuine cases proceed further in the criminal justice system. The provision helps in streamlining the judicial process, conserving the time and resources, and uploading the integrity of the legal system by focusing on valid cases deserving of trial and redressal. So we will be going through with this one of the case example, wherein in Chandra Dev Singh versus Prakash Chandra Bose, the Honorable Supreme Court overturned the magistrate decision to dismiss a complaint in the case in question on the grounds that the magistrate must be satisfied that there is a sufficient justification for the continuation of the proceeding, not just that there is a sufficient justification for conviction in the complaint that was submitted to the court. So the magistrate must be satisfied there is a sufficient justification for the continuation of the proceedings. If the magistrate feels that yes, the proceedings has the sufficient grounds, then only the magistrate can issue the process. So in this case, there is one more another case wherein the Supreme Court has ruled that where a complaint is dismissed by a magistrate under Section 203 of CrPC, then the accused or suspected person have the legal right to be heard in a revision petition filed by the complainant before the High Court or Sessions Court. Normally, what happens that if the matter is being dismissed by the magistrate court, then the remedy is to file a revision petition before the Honorable High Court or Sessions Court. So if the revision petition is filed before the Honorable High Court or Sessions Court, then there is a legal remedy and there is a legal right that it should be heard by the other party. So this case clearly states that the accused or the suspected person have the legal right to be heard in a revision petition filed by the complainant before the Honorable Court or Sessions Judge. If the revisional court overrules the magistrate order and restores the complaint for a fresh consideration, then the accused have no right to participate in the proceedings until the magistrate decision is on the issuing process. The Supreme Court overruled the judgments of High Court that held otherwise, confirming that the accused right to be heard in such revision petition is not applicable under the magistrate consideration for the issuing process. So I would like to conclude that Section 203 of the CrPC holds significant importance in the process of filing a complaint before the magistrate. This section grants the magistrate the power to examine the complaint and the evidence presented by the complainant and witness under Section 200 and 202. The magistrate's crucial duty is to apply his mind to determine whether there is a sufficient grounds to proceed with the case. If yes, then only the magistrate will issue a notice, that is the process, to the other side. On the other hand, if the magistrate is not satisfied with the evidence and finds that there is no prima facie offense, then he will dismiss the complaint under Section 203 and they will give the brief order as to why they have not considered the case and they have dismissed the complaint under Section 203. So this careful evaluation ensures the fairness, transparency, and protection against arbitrary dismissals, upholding the integrity of the criminal justice system. Now moving to the next topic, that's appearances. So there is a process to compare for the appearances which has been laid down under Section 61 to 90 of the CrPC. There are other rules also which has been stated under Section 87 to 90 of the CrPC. So basically, the process to make an appearance is that it is being introduced to meet the ends of the justice. It is crucial to produce the accused and other witness or related parties before the court whenever needed. If the accused is found guilty at the conclusion of the trial, he must be present in person to receive the sentence. Also, his presence is necessary if the imprisonment is to be enforced. So there are 6 ways to compel a person to appear in court. Number 1, that is summons, which has been laid down under A chapter 6 of CrPC. Then second one is warrant, which has been laid down under B chapter 6 of CrPC. Then it's warrant in lieu of summons, which has been laid down under chapter 6 of CrPC. Then it's proclamation of a absconder, and then it's attachment of his property. And there is also a bond with or without sureties to appear before a court on a certain date. So the rules regarding the process is being mentioned under Section 87 to 90 of the CrPC. So there is one case where the court believes that the person summoned has absconded or will not obey the summons. Then Section 87, the court can make the person to appear before the under case 2. where although the summons is proved to have been served in time, the person summoned has, without any reasonable cause, failed to appear. Case 3. On breach of a bond for appearances. So the process to compel appearances is mentioned under section 61 to 90. There are other rules regarding the process which has been mentioned under section 87 to 90 of the CrPC. So these provisions have been introduced to meet the ends of the justice, and it is very critical to produce the accused and other witnesses before the court whenever needed. If the accused is found guilty at the conclusion of the trial, then he must to receive the sentence, and so the imprisonment can also be enforced. So there are 6 ways where we can compel a person to appear in the court: that summons, warrant, then it's warrant in lieu of summons, then proclamation of an absconder, then attachment of his property, then a bond with or without sureties to appear before a court on a certain day. So there are other rules regarding the process which has been mentioned under section 87 to 90. So there are the cases where the court believes that the person summoned has absconded or will not obey the summons, where the court feels that where although the summons is proved to have been served in time, the person summoned has without reasonable cause failed to appear. And on the case 3, where on the breach of a bond for appearing, a magistrate ought not to issue a warrant either in lieu of or in addition to summons in a summons case unless he has previously recorded the reasons for his so doing. So basically, if you must have seen that there are the things wherein get for an anticipatory bail, the accused signs a PR bond, that is personal result, release bond. So if there is a breach of a bond, then what happens is that although the anticipated bail can be challenged, I mean it can be the magistrate can direct the police officers to arrest it, or the magistrate can give the directions to the police to issue a warrant against that person and compel the persons to appear before the honorable court. And so this is the case wherein it has clearly stated that when the court can compel a person to appear before the honorable court. So section 87 states that there the magistrate courts can issue a warrant. So a court is empowered by this court to issue a summons for the appearance of any person. The court may issue a warrant for arrest after recording its reasons in writing. So there are the conditions that if either before the issuance of such summons or after the issue of the same, but before the time fixed for his appearance, the court sees reasons to believe that he has absconded or will not obey the summons. So there are the things wherein the court also feels that he is not complying with the anticipatory bail conditions. Then in that case also the court can issue the warrant against that person. Or if the person has been absconded, then also the court can compel the persons to appear before the honorable court. So if at such time he fails to appear, then the summons is proved to have been duly served in time to admit of his appearances in accordance therewith, and no reasonable excuse is offered for such failure. The person will have to sign a bond. So the bond is that a bond for appearances which has been mentioned under section 88 to 89. So this is wherein the court feels the surety that yes, the person has executed a bond, that bond can be executed with or without surety for his appearances in the court. So normally what happens is that I'll give you an example wherein whenever an anticipated bail is granted to an accused, then you must have noticed that the person must have to get the bond executed. That is known as a PR bond, that is personal release bond. So in that thing, it can be under the cash surety, or a person will have to manage a surety. So after getting all the compliances being done, then only the person is released on a bail. These are the conditions wherein the person can be released on a bail. So under section 88, it is a power to take the bond for appearances. So when of any person for whose appearance or arrest the officer presiding in any court is empowered to issue a summons or warrant is present in such court. So such officer may require such person to execute a bond that can be with or without surety for his appearances in such court or any other court. Section 89 clearly states that arrest on breach of bond for appearances. So any person who has breached such bond, then in that case, the police officer will issue a warrant against that person, and the court may direct the police officer to get that person arrested and produced before them. So supplementary section under 90 states that there is a provision of this chapter generally applicable to summons and warrant of arrest. The provision contained in this chapter relating to a summons and warrant and their issue, service, and execution. The provision shall also far as may be applicable to every summons and every warrant of arrest issued under this code. So basically, I would like to conclude that these are the provisions which have been stated under CrPC, which states that when a person can be compelled to appear before the honorable courts. Okay, I'll be moving to the next topic, that is arrest. So what is an arrest? Arrest means a seizure or a forcible restraint, an exercise of the power to deprive a person of his or her liberty, the taking or keeping of a person in custody by legal authorities, especially in response to a criminal charge. So under the Indian law, CrPC provision, there is a chapter 5 which states that under section 41 to 60 talks about the arrest of a person, but it is nowhere defined clearly. So there are two types of arrest. That is, wherein an arrest is made in view of warrant issued by the magistrate. And second, an arrest is made without any such warrant, but in accordance with some legal provisions permitted permitting such arrest to be done. So basically, who can arrest? The arrest can be made by a police, magistrate, and even a private person. Under section 41(1) of CrPC says any police officer may, without an order from a magistrate and without a warrant, can arrest any person who has committed a cognizable offense. So basically, who can arrest? The arrest can be made by police, magistrate, and even a private person. Under section 41(1) of CrPC says that any police officer may, without an order from a magistrate and without a warrant, arrest any person who has committed a cognizable offense, who is in possession of stolen property, or is a state offender, who obstruct a police officer in discharging of his duty, or who attempts to escape from lawful custody, or who is declared as a deserted from any of the armed forces of the Union, or who is released a convict and breaches his contract of release. So these persons can be arrested by the police officers. So section 42 authorizes a police officer to arrest a person for an offense which is of non-cognizable if the person to be arrested refuses to give his name and residence. Under section 43, it gives the right to a private person like you and me to carry out an arrest of a person who in his presence commit a cognizable or a non-bailable offense, or who is a proclaimed offender. Under section 44, an arrest by magistrate as per section 44(1) of CrPC, the magistrate has been given the power to arrest an individual who has committed an offense in his presence and also commit him to the custody. So in short, these are the sections wherein the police officers can arrest the private persons can arrest, and the magistrate can also arrest a person. However, the CrPC exempts the members of armed forces from being getting arrested for anything done by them in discharge of their official duties, except after obtaining the consent of the government, which has been laid down under section 45 of CrPC. Section 46 of CrPC explain how arrest is made with or without the warrant. Section 46 subsection 4, there is a special protection as females that forbids arrest of a woman after sunset and before sunrise, except in exceptional circumstances, in which case the arrest can be done by a woman police officer after making a written report, obtaining a prior permission from the concerned judicial magistrate of first class within whose local jurisdiction the offense is committed or the arrest is to be made. So this is the provisions wherein the females cannot be arrested after the sunset and before the sunrise. If so, if any police officer wants to arrest, then in an exceptional circumstances this section applies. That is section 46 subsection 4. So constitutionality of section 106 and 151 of CrPC. For the purpose of arresting without a warrant, a police officer may pursue such an individual in any place in India, which has been stated under section 48 and section 49 of the code. It says that the arrested person shall not be subject to any unnecessary restraint or physical inconvenience unless it is required to do so to prevent his escape. So under section 151, it gives the power to the police officers to arrest a person without a warrant on the suspicion that he has committed a cognizable offense. However, this comes with certain conditions. The anticipated offense should be cognizable and the officer should feel that the offense would be prevented only by an arrest of the suspect. Section 107 also gives the similar power to the magistrate. But however, numerous petitions have been filed questioning the constitutional validity of this section, as it gives plenty of room for misuse of the powers under this section. So there are some landmark cases, that is Birendra Kumar Rai versus Union of India 1992. It was held that to make an arrest, the police officer need not be handcuffed the person, and it can be completed by spoken words also if the person submits to custody himself. It was held in the case of Barosa Ramdayal versus Emperor 1941 that if a person makes a statement to the police admitting himself of committing an offense, he would be considered to submitting to the custody of the police officer. Also, if the accused goes to the police station as directed by the police officer, he can again consider to have been submitted to the custody. In such case, physical contact is not required. So, in the case of Kultesh Singh versus Circle Inspector of Police, 1992, it was held by the court that keeping a person in custody in the police station or confining the movement of a person in the precincts of the police station amounts to arrest of the person. In the case of Megha Patkar versus State, 2007, this is a case in MP regarding the Sardar Sarovar project. Some landowners and other people who were affected by this project in MP gathered on the road. They were shouting the slogans and demanded the land for land and other rehabilitation measures. The gathering was peaceful without disturbing the public order. But despite this, the police took it upon themselves to beat the protesters and arrest all of them under section 151 of CrPC and also summoned by the magistrate under section 107 of the CrPC. There were women and children too among the protesters. When the protesters did not submit a personal bond, then sending them to the jail still amounted to the violation of section of Article 21 of the Constitution of India. So there are some rights of an arrested person in India. The accused in India are afforded certain rights, the most basic of which are found in the Indian Constitution. That is Article 21 of the Indian Constitution, which says that there are some rights of an accused. The treatment of such people has to be human and in the manner prescribed by the law. Hence, the accused has been provided with certain rights under the law. So there are some grounds of arrest, that is right to be informed. So this right has been given by the state of a fundamental right in the Indian Constitution. Article 22 sub 2 of the Indian Constitution says that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, nor he shall be denied the right to consult and to be defended by a legal practitioner of his choice. This right is very important for the person arrested as he may be innocent. If he gets to know of the grounds of arrest, then it enables him to apply for bail or in appropriate circumstances for a writ of habeas corpus or to make fast and suitable an arrangement for his defense. Also, it gives the arrestee the right that any one person close to him is informed about his arrest immediately. So, Madhu Limai case is an example over here. So there is also a right to silence. That just because the accused or arrested person choose to be silent under interrogation doesn't mean that he is guilty. There is much speculation that if this right is to be exercised in modern times, as mentioned in the Justice Malimat Committee report. So in Nandini Satak versus PL Dhani, in this case, it was mentioned that no one can forcibly extract statements from the accused, who has every right to keep silence if he has chosen so. So, you must have also heard that any statement given to the police officer is not admissible to the court of law. So, this is where even if the police try to extract the statement forcibly from an accused, such statement given to the police officers is not admissible to the court of law. Then there is also a right which is to the accused that it's right to be released on bail. So under Article 21 of the Indian Constitution is that every individual shall have a right to liberty as per procedures established by law. However, an accused cannot be given all these liberties till he is proven innocent. But he needs to be informed that he has a right to apply for bail in bailable offences and even in non-bailable offences. So the bail is granted by the court after taking into the factors, that is nature and seriousness of the offence. So this has been stated in the case law, that is Uday Mohanlal Acharya versus State of Maharashtra. So there is also a right to be taken before magistrate without delay. So whenever there is an arrest made without a warrant, then the person making such an arrest is duty bound to present the accused before the magistrate within 24 hours. That is excluding the time taken for traveling from the place of arrest to the magistrate court. This has been stated under the case law, that is State of Punjab versus HF Singh. So there is also a thing that's rights regarding detention. If the arrested person is not produced before a magistrate within 24 hours of the arrest by the police officer, then he shall be held guilty of wrongful detention. This right has been created with a view that the arrestee is not compelled to give any confession or a means of compelling people to give information. So the police station don't act like prisons for which they are unsuitable. This has been stated under the Dunupatti Keshavaram versus Nafisul Hassan. So there is also a rights at trial. Keeping with the international system of law, our constitution upholds the fair trial system, and the same is also seen our procedural procedural law. So there should be a fair trial to protect the accused. So and there should be a speedy trial. So there is a case wherein it has been stated in Husainara Khatun, wherein it is stated that there is a right of an accused for a speedy trial. So there are some other cases also which has been stated in Ratiram versus Territory of Madhya Pradesh, and there is also a case law wherein which has been stated in Jahira, Habibullah Sheikh, and others versus Province of Gujarat and others. There is also a right to consult a legal practitioner. That is a right to consult an advocate. So the Supreme Court has upheld the right of consulting a legal practitioner by an accused as a constitutional right, which has been mentioned under Article 21 and 22, sub Article 1 of the Constitution of India. So there is a case law, that is Janardhan Reddy, State of Hyderabad. This is an example which clearly states that there is a right to consult a legal practitioner. Then there is also a right for a free legal aid. So in India, this facility is being provided to all the poor accused, wherein they are not able to engage a legal practitioner or an advocate. In such things, an application is made before the Honorable Court to get a free legal aid, and then the Honorable Court can provide a free legal aid to the accused. There is also a free legal aid services, and for that, it helps the accused to get a free legal aid. Then there is a right to be examined by a medical practitioner. So whenever there is an arrest for such things, there is always a right for an accused to get it examined by a medicinal practitioner. So this acts as a check to ensure that if there was any torture by the powers that has been done during an interrogation or during an custody. So there is a case law for it, that is Anil Lohande versus State of Maharashtra. So you must have seen that if there is any humiliation done by the police officers or during an interrogation, there is a torture being done by the police officers, then there is a right to then accused, wherein they can be examined by a medical practitioner. There is also a right, that is right of an accused to produce the evidence. It is a very important right because every right has, every accused has a right to produce an evidence before the honorable court, and it gives a very fair trial. So there is also a case law, that is Joginder Kumar versus State of UP. So I would like to conclude that it is the first and foremost duty of the police to protect all the individuals and their right in society, which also includes the arrested person. Thus, it is the duty of the police to also protect the rights of the accused and make sure that they are treated fairly according to the proceedings established by the law and not harassed unnecessary and not tortured. The police should make sure that the person arrested is informed about his rights like grounds of arrest, if he or she is entitled to bail on and produced before a magistrate within the 24 hours. Then there are the other things also wherein the police has to inform the accused, that is they have to uh, they have to state the charges which have been levied against them, then they have to get it produced before the honorable court within 24 hours. So these are the rights of an accused, and these are the things wherein the police officers should follow the due process of the law. So this, I would like to conclude the topic, that is of an arrest. I hope everyone is clear for this topic. Then moving to the next topic, that is habitual offender. So habitual offenders are the offenders who regularly commit the crime. So those who commit the offense, and they every time commit the offenses day by day, or there are numerous of FIRs being lodged against the person, they are being known as a habitual offenders. And it can also be stated that when a person is previously convicted and subject to a correction, commits another crime, then also they are being known as a habitual offender. So the concept of habitual criminality proceeds on the theory that a person may, by a repetition of offenses, can commit against the offenses can commit against the state, render himself responsible to a statutory prohibition, thereby he is prevented from giving further expression to his criminal behavior. It should be noted that the application of the statute turns on the finding a court of a record that the accused is a habitual criminal. Criminality, therefore, regarded as an offense per se known to the law. So these are the things wherein who are the habitual offenders who have these include that they are the illegal drug possessions, then petty theft such as shoplifting, then trespassing, then petty offenses, then there is also disorderly conduct and drunkenness, then there is traffic violations. So these are the habitual offenders. So under section 73 of the Indian Penal Code, it provides, just a moment, yes, it provides for the enhancement punishment for a person having a previous conviction. Under section 110 of the Criminal Procedure Code, it is a preventive measures would permit the binding over of any person who is habitual addicted to a crime or other types of antisocial behavior to deal with the problem. So the legislative have made the provisions which are as following, that is enhanced punishments, keeping track of the movement of the offender after his release, then taking preventive actions in the nature of security for good behavior, then there is a surveillance, and it can be miscellaneous also. So, what happens to the habitual offenders? There is a longer jail sentences, then there is a higher fines, then there is intense rehabilitation for addiction problems, then there is a supervised probation, then probation on owning or possessing firearms, then there is a loss of other civil liberties such as voting rights. So this is a very unique case wherein under section 427 of CrPC, this has been stated by the Allahabad court, wherein it states that sentences imposed on habitual offender in separate trials can't run concurrently without considering the gravity. So with this, I conclude with the topic wherein which says that if a person is committing the crime and is being convicted of a previous crime, and he's also committed another crime, then he will be treated as a habitual offender. And in such cases, normally, if such habitual offenders try to get the bail or an anticipatory bail, then the honorable courts may reject such application, and in such cases, the habitual offenders does not get the bail easily. So I'll be moving to the next topic, that is bail. So you must be getting a question that when this bail can be granted in a non-bailable offense and what is a bail. So I'll be covering up such topics, that when a bail can be granted, when the bail can be cancelled. So what are the procedure of getting the bail? So basically, bail forms one of the basic parts of the criminal jurisprudence. So in this bail topic, I'll be telling you as to what are the procedure of getting the bail, then when the bail can be cancelled, then when the bail can be granted in a non-bailable offense. So bail forms one of the basic parts of criminal jurisprudence and is a well-recognized practice among most legal systems all around the world. So the question of bail arises when the person is detained by law enforcement. Bail can be granted after the security is deposited the monetary value of the security is decided by the court. So basically, as mentioned about the Criminal Procedure Code under section under 1972 does not define the bail. Although the term bail generally means the release of an accused in an offense after he gives surety to abiding by the conditions which has been imposed by the court and stand his trial before the court. So whenever the court grants a bail, there are the conditions which has to be followed by the accused. That is, he has to give the surety, then he has to remain present before the police station during an investigations. Then he has to remain present before the trial. Whenever the trial is before the court, then he has to remain present. So there are two types of offenses. That is bailable offense and non-bailable offense. So in bailable offense, they are the offenses which are of less serious in nature. That is of with 3 years or less imprisonment. So in these types of offenses, getting bail is considered as a right of an accused. So some examples can be that theft, bribery, cheating, etc. In non-bailable offense, these are the offenses of serious nature. That is, the punishment is very high. Even it can be life imprisonment or a death sentence. So bail is not considered as a right in this offense. The court has the discretion to grant bail after hearing the facts of the case. So over here, it can be rape or homicide, etc. So these are the, or it can be murder also. So these offenses which are of serious nature are considered as a non-bailable offense. Then there are types of bail. That is regular bail, anticipatory bail, and interim. The regular bail is mentioned under 437 and 439 of the CrPC. So basically, it is provided by the competent authority after the accused is arrested under section 437 and 439 of the CrPC. In this case of non-bailable or bailable and permissible offense, a person can apply for a regular bail. Then a person can apply for an anticipatory bail, that is before an arrest, which I have covered in the previous PPT. So under section 438 of the CrPC, it provides that any who has an apprehension of getting arrested or who feels that an FIR can be lodged against that person, then a person can get the anticipatory bail before the Honorable High Court, Sessions Court, or before the Honorable Supreme Court. It is an interim bail, which states that there is a temporary relief, that is a temporary bail granted by the court till the anticipatory or regular bail application is pending before the court. So basically, how can you get a bail? In regular bail, in bailable offense, this is in this the offense, it is a person's right to get a bail, which is provided that either by the police officer in charge or the case itself, or by the judicial magistrate court on furnishing the surety by the arrested person. So in this, the person has to give the surety, and in this regular bail is that after getting an arrested, if the person is arrested, then the person has to file a regular bail, and the person will have to give the surety on execute a PR bond. Then in non-bailable offense, in this offense, getting a bail is not the right of an accused. It depends upon the discretion of the court or the authority. So if the offense has the maximum punishment of life imprisonment or death penalty, then to grant the bail, then in that cases the person cannot be granted a bail. So if the offenses has a maximum punishment of life imprisonment or death penalty, then the honorable court may not grant bail to the accused. So there are the reasons on which bail in a non-bailable offense are granted. So if the accused is a woman or a child, then a bail can be granted in a non-bailable matter. If there is a lack of adequate evidence, the court can grant bail in a non-bailable offense on a discretion. If there is a delay in registering the FIR by the complainant, then also the bail can be granted. If the person accused is physically or gravely sick, if there is some collaboration as to personal enmity between the accused and the person who has filed the criminal matter. There is also a thing wherein the police has to file the charge sheet within 90 days. So if the police fails to file the charge sheet within the 90 days, then also in such cases the court may grant the bail to an accused. So there is one case wherein the Supreme Court in the case of Rukmani Mahato versus State of Jharkhand, it directed the trial court to not grant a regular bail in any case in which the anticipatory bail is already granted. So the second one is the anticipatory bail. This can be filed in both, that is bailable and non-bailable offense. Anticipatory bail is filed whenever the accused feels that there is an apprehension that an FIR can be filed against that person and there is an apprehension of getting arrested. Then such anticipatory bail application is filed before getting an arrest by the police officer. So there are the factors which are being taken under consideration before granting an anticipatory bail, that is nature and gravity of the accusation, prior criminal record of the accused, the possibility of the applicant fleeing from justice where the accusation has been made to damage the reputation of the applicant. The court can either reject the application forthwith or issue an interim order for the grant of anticipatory bail. So there are the conditions wherein the court see that if the anticipatory bail is being granted to an accused, then whether such conditions will be complied by the accused or not. The court also look into an aspect that what are the nature and gravity of the accusation levied against the accused. The prior criminal record of an accused is also being considered under this thing while granting an anticipatory bail to an accused. So conditions imposed by the courts after granting the anticipatory bail. So there are the conditions wherein the court impose to an accused, that is that the person shall make himself available for interrogation by the police officer. Then the person shall not directly or indirectly threaten or tamper with the witness. Then the person shall not leave the India without the prior permission of the court. There is one more case law which says that the Supreme Court in case of Sushila Agrawal and others versus state and others state that anticipatory bail is not for the fixed period of time. It can continue till the end of the trial. So interim bail is where that if the bail application is pending, then an interim bail is granted to an accused. So there is one case law which says that the Supreme Court in the case of Sukhwant Singh versus State of Punjab states that the court shall have the inherent powers to grant the interim bail while hearing a plea for the regular bail. It is also advised that the judicial magistrate should also exercise the power of granting the interim bail to the accused to prevent the abuse of criminal law. But if the tenure of interim bail expires before granting of regular or anticipatory bail, then the accused can be arrested. So interim bail is for a small period of time. Then there is a cancellation of bail. There are the numerous cases wherein the bail can be cancelled by the Honorable High Court, Sessions Court, and by the Supreme Court of India. So these superior courts use the power mainly when the order is being perverse or passed without the due application of mind or in violation of any substantive or procedural law. So Section 437, subsection 5 provides for the cancellation of bail by the magistrate court on the ground of misuse of liberty after the grant of bail or other supervening circumstances. There are numerous cases wherein the court feels that the person is not complying with the conditions, the person is not remaining present before the trial, the accused is not attending the police station in every month, the person is trying to misuse the law by threatening the accused, or the person is trying to temper the evidence, then in such cases the bail can be cancelled. Yes, you can read that it's clearly stated that it's an attempt to tamper with the evidence or witness, threatens the witness, then fails to remain present before the concerned police station. So these are the grounds wherein if the court feels that the accused is not complying with the conditions which have been imposed, which have been stated at the time of granting the bail, then the honorable courts can reject or the honorable courts can cancel the bail and they can direct the police officers that such persons be arrested. So I would like to conclude that the bail is being mentioned under the CrPC. It is for the to get the free trial and it is for the right of an accused. But such a thing must be done in a very deliberate manner. Not in a deliberate. I mean, it should be done in a very careful manner because there are the conditions being imposed by the honorable courts, and such conditions must be. I mean, such conditions must be carefully complied by the accused. So this is why the concept of bail came into existence to stop the misuse of criminal law. So I will be going to the next topic, that is Juvenile Justice Board. So Juvenile Justice Board is already explained in the code of CrPC, which states that the state government shall constitute for every district one or more juvenile justice board for exercising the power and discharging its functions relating to the children in conflict with the law under this Act. The board shall consist of a metropolitan magistrate or a judicial magistrate of first class, not being chief metropolitan magistrate or the chief judicial magistrate, herein referred as a principal magistrate with at least 3 years experience, and social workers selected in such manner as may be prescribed, of whom at least one shall be woman, forming a bench, and every such bench shall have the powers conferred by the Code of Criminal Procedure 1973. So this clearly states that no person shall be eligible for a selection as a member of the court if he has any past record of violation of human rights or child rights, or he has been convicted of an offense which involves moral turpitude, and such conviction has not been reversed or has not been granted full pardon in respect of such offense, or he has been removed or dismissed from service of the central government or a state government, or has an undertaking or corporation owned or controlled by the central government or a state government, or he has ever indulged in the child abuse or employment of child labor or any other violation of human rights or immoral act. The Juvenile Justice Board also gives the thing that is training to be given to all members, that is including the principal magistrate of the board, that is protection, rehabilitation, legal provisions, and justice for the children as may be prescribed is provided within the period of 60 days from the date of appointment. So the term of office of the members and the manner in which such members may resign shall be as which has been prescribed under the code of CrPC. So these are there are the things wherein the member can be terminated after holding an inquiry by the state government that if he has been found guilty of misuse of power vested under this act, if he fails to attend the proceedings of the board consequently for 3 months without any valid reasons, if he fails to attend three-fourths of the sittings in a year, or if he becomes under a subsection during his term as a member. So this is a way wherein juvenile justice court is made in the criminal procedure code. Now moving to the next topic. So basically, what is an FIR and what amounts to the first information and when it cannot. So basically, I'll be covering this topic. So basically, an FIR is a very important document as it sets the process of criminal justice in motion. It is only after the FIR is registered in the police station that the police can take up the investigation of the case. So basically, an FIR is a written document prepared by a police when they receive an information about the commission of a cognizable offense. It is a report of information that reaches the police first in point of time, and that is why it is called as a first information report. It is generally a complaint lodged with the police by the victim of a cognizable offense or by someone on his or her behalf. So anyone can report the commission of a cognizable offense either orally or in writing. So basically, the FIR is not defined in the Indian Penal Code 1973 or in any other law. However, in police regulations or rules, information recorded under Section 154 of CrPC is known as a first information report. So there are three important elements of an FIR. The information must relate to the commission of a cognizable offense. It should be given in writing or orally to the head of the police station. It must be written down and signed by the informant, and its key points should be recorded in a daily diary. Then what happens after an FIR is filed? The police will investigate take the evidence in the form of statements of witness or other scientific materials. They can arrest the alleged person as per the law. If a final report mentions that there is no evidence is been found by the police, in that case, the police fails to lodge an FIR. If the police feels or if during an investigation the police comes to a conclusion that no offense has been committed, then a cancellation report will be filed. If the police thinks that there is no trace of the accused person, then the police will file the untraced report. However, if the court feels that the investigation is not properly done, then the court can order. So there are the things wherein if imagine a situation wherein you approach a police station, and what if the police fails to lodge an FIR? So under section 154(3) of CrPC, if a person is aggrieved or if a person is refused by the police officer to lodge an FIR, then he can write a complaint to the superintendent or to the ACP or to the DCP or to the commissioner in writing that that an FIR is not being lodged by the concerned police station, and so this is a cognizable complaint, and therefore an FIR must be lodged by the concerned police station. So if they are satisfied that a cognizable offense is made out on the complaint, then they will direct the police to register an FIR and conduct an investigation. What is a zero FIR? Zero FIR is basically a FIR wherein if the concerned police station fails to lodge an FIR, then the person can lodge an FIR at a different police station, and that different police station can forward the complaint to the jurisdictional police station. This is known as a zero FIR. So basically, when a police station receives a complaint regarding an alleged offense that has been committed in the jurisdiction of another police station, so it registers an FIR and then transfers it to the concerned police station for further investigation. This is called as a zero FIR. But however, no regular FIR number is given. So after receiving the zero FIR, the concerned police station registers a fresh FIR and starts the investigation. So basically, what is cognizable offense and a non-cognizable offense? Cognizable offense means a cognizable offense in which the police may arrest a person without a warrant. They are authorized to start investigation into a cognizable case on their own and do not require any orders from the court to do so. However, in non-cognizable offense, a non-cognizable offense is an offense in which a police officer has no authority to arrest without a warrant. So the police cannot investigate such an offense without the court permission. Non-cognizable offense, an FIR under section 155 of CrPC is registered. The complainant will be asked to approach a court for an order. The court may then direct the police to conduct an investigation on the complaint. So basically, what is the difference between a complaint and an FIR? The CrPC defines a complaint as to any allegation made orally or in writing to a magistrate with a view of his taking an action under this code that some person, whether known or unknown, has committed an offense but does not include a police report. However, an FIR is a document that has been prepared after verifying the facts of the complaint, after investigating the case, then only an FIR has been lodged. The FIR may contain the details of the crime and the alleged criminal details. It appears that a cognizable offense has been committed, then an FIR under section 154 will be registered and police will open for an investigation. If the police thinks that there is no offense being committed, then the police will close the inquiry. So this is the way wherein an FIR can be lodged against a person. And one more thing, that if the police fails to lodge an FIR, then under section 482 of CrPC, a person can approach before the Honorable High Court, and the Honorable High Court can direct the concerned police station to lodge an FIR. So these are the legal remedies available to a person that if a person is denied to lodge an FIR. With this, I conclude the topic of FIR.
Okay, Hitesh, thank you so much. Very informative webinar.
Thank you.